The Supreme Court chamber, usually a bastion of solemn deliberation, was electric with tension. What began as a routine session had spiraled into a spectacle that would be etched into the annals of American legal history. At the heart of it stood Florida Attorney General Pam Bondi, her navy suit crisp and her demeanor unshaken, facing two of the nation's most powerful jurists, Chief Justice John Robberts and Justice Amy Coney Barrett. The case, centered on allegations of judicial overreach, had already drawn intense scrutiny from legal scholars, journalists, and the public. But no Coney, and not the justices, not the packed gallery, not even the seasoned reporters could have anticipated the seismic shift about to unfold. The air was thick as Bondi approached the podium, her notes meticulously arranged. Chief Justice Robberts, perched at the center of the bench, fixed her with a gaze that mixed impatience with thinly veiled disdain. To his right, Justice Barrett leaned back, a faint smirk playing on her lips. The case had been contentious from the start, with Bondi's office filing a bold challenge to the court's conduct, alleging patterns of bias and improper influence. The written submissions had been met with skepticism, and now, as Bondi prepared to argue, the justices seemed poised to dismiss her outright. Miss Bondi, Roberts began, his voice carrying the weight of decades on the bench, I trust you've brought something more compelling than the speculation we saw in your filings. A ripple of nervous laughter spread through the gallery, where legal analysts, court watchers, and reporters sat shoulder to shoulder. Bondi, undeterred, adjusted her glasses and responded evenly, Your Honor, the evidence we've gathered is both substantial and irrefutable. Before she could elaborate, Barrett cut in, her tone sharp. Substantial. That's a generous word for a filing built on circumstantial threads and conjecture. The gallery stirred, sensing the unusual hostility. The Supreme Court arguments were known for their rigor, but this level of open derision was rare. Roberts raised a hand, his expression almost theatrical in its condescension. Perhaps, Miss Bondi, you could explain why we shouldn't dismiss this case for wasting the court's time? Bondi took a measured breath, her composure a stark contrast to the justice's pointed barbs. If the court would permit me to present our findings in full, she began, only to be interrupted again by Barrett. We've read your findings, the justice said, her voice dripping with dismissal. They're little more than conspiracy theories dressed up in legal jargon. Reporters exchanged glances, scribbling furiously. Justice Sonia Sotomayor shifted uncomfortably in her seat, her expression hinting at unease with her colleagues' approach. For nearly an hour, Bondi endured a relentless barrage. Roberts and Barrett took turns questioning her competence, interrupting her arguments, and exchanging knowing glances that drew chuckles from their clerks. Miss Bondi, Barrett said at one point, her patience exaggerated, can you point to any precedent that supports your rather broken bar creative interpretation of judicial accountability? The implication was clear, they had already made up their minds. The other justices remained largely silent, some visibly troubled by the exchange but hesitant to intervene. The gallery buzzed with discomfort. This wasn't just a legal argument, it was a public dressing down. Roberts leaned forward, his tone patronizing. The American people deserve better than this theatrical performance, he said after Bondi attempted to cite a prior ruling. The words hung in the air, a challenge to her legitimacy. But Bondi, her resolve unshaken, seized the moment. With all due respect, Your Honor, she said, her voice cutting through the tension like a blade, I have the floor. The chamber fell silent. Roberts' eyebrows shot up, and Barrett's smirk froze. The audacity of Bondi's interruption, a direct challenge to the Chief Justice stunned the room. You have the floor at the discretion of this court, Roberts replied, his voice icy. And I trust this court still respects its own procedures, Bondi countered, locking eyes with him, including the right of presenting counsel to be heard without constant derision. The gallery held its breath. For a moment, no one moved. Then, with a curt nod, Roberts said, Proceed, Miss Bondi. His tone betrayed barely contained irritation. Bondi straightened, her posture signaling that the real fight was just beginning. As she resumed, the atmosphere shifted. Gone was any trace of defensiveness. In its place was a steely determination. This case, Bondi declared, is not about partisan politics or undermining judicial authority. It's about upholding the constitutional principles this court was founded to protect. She reorganized her notes with deliberate calm, her every movement commanding attention. Observers later noted the subtle change in her demeanor, a prosecutor's focus replacing the earlier restraint. Bondi began to build her case with surgical precision. In Thompson v. Federal Election Commission, she said, turning to Barrett, Justice Barrett wrote that judicial independence must be balanced with accountability. I quote, "No office, however revered, stands completely outside the bounds of constitutional oversight." Barrett shifted in her seat, clearly unprepared for her own words to be wielded against her. Bondi didn't pause. Similarly, Chief Justice Robberts, in your confirmation hearings, you stated that judges are servants of the law, not the other way around. Would you agree that this principle applies universally? Roberts' eyes narrowed. Miss Bondi, are you attempting to cross-examine this court? He asked, his voice tight. Not at all, Your Honor, she replied smoothly. I'm establishing the legal principles we presumably Sharia unless those principles apply selectively. The challenge, subtle but unmistakable, hung in the air. Justice Elena Kagan glanced at Roberts, her expression unreadable. The other justices leaned forward, suddenly more engaged. What had begun as a one-sided dismantling was becoming a contest of intellect and principle. Bondi pressed on, citing prior opinions by both Roberts and Barrett, exposing contradictions between their past rulings and their current dismissive stance. In Harmon v. State Department, she said, nodding toward Roberts, this court, under your leadership, held that documented patterns of behavior constitute admissible evidence when establishing institutional bias. That precedent seems directly relevant here. The gallery stirred as legal reporters scribbled frantically, sensing a shift. Bondi's command of case law was proving formidable, turning the justice's own words into weapons. When Barrett attempted another interruption, Bondi countered with a citation so precise it left the justice momentarily speechless. Justice Barrett, I'm simply applying the three-part test you established in Richardson, Bondi said, her tone respectful but unrelenting. Unless that framework no longer stands. Barrett's face flushed as her own legal reasoning was turned against her. The contrast was striking. Bondi's professionalism stood in sharp relief against the justice's earlier mockery. The room began to buzz with whispers from legal experts, who sensed the tide turning. The documentation we've submitted, Bondi continued, demonstrates a pattern that cannot be dismissed as coincidental or speculative, not when viewed through this court's own standards of evidence. She paused, letting the weight of her words settle. Unless those standards are flexible depending on who stands before this court. The implied question of whether justice was truly blinded resonated deeply. Several justices exchanged concerned glances, and the mockery that had dominated the session's opening faded entirely. Then came the moment that changed everything. Bondi reached into her briefcase and withdrew a sealed envelope, her movements deliberate and confident. Your Honors, she said, her voice clear and steady, the Department of Justice has been investigating judicial irregularities for the past 14 months. Roberts straightened, his expression darkening. Miss Bondi, if you're suggesting I'm not suggesting, Your Honor, Bondi interrupted, her tone calm but firm. I'm presenting established facts. She broke the seal and extracted documents bearing official government watermarks. With the court's permission, I'd like to enter file JR 7923 into evidence via internal communications between certain members of this court and external parties with cases pending before it. The silence was deafening. Justice Clarence Thomas whispered something to Justice Samuel Alito, whose face tightened. Barrett spoke quickly, her earlier confidence replaced by unease. Such evidence would be highly irregular and potentially inadmissible. Bondi nodded, as if anticipating the objection. Under normal circumstances, perhaps, but these documents were obtained through a FISA warrant approved by Judge Marcus Wilkinson of the D.C. Circuit, following preliminary evidence of potential violations of 18 U.S.C. Section 201. The courtroom erupted in murmurs. Section 201 addressed bribery of public officials, including federal Judge Essa, an accusation of staggering gravity. This is outrageous, Roberts declared, his face reddening. "This court will not be ambushed. The evidence is substantially corroborated," Bondi interjected, unfazed by whistleblower testimony from 2 former clerks and electronic records subpoenaed from 3 telecommunications